theme running through some of the amendments to Part 162 in the Department's significant revisions to that section of the Code of Federal Regulations, or that part of the Code of Federal Regulations, which gives tribes a lot of deference in the DOI approval process. So let's go on to slide 7. So the HEARTH Act doesn't just authorize tribes just straight out of the box to say, go ahead and lease your trust land and restricted fee land without any kind of DOI input. Rather, what happens is that tribes are authorized to lease their lands without BIA review or secretarial approval as long as a couple of conditions are met. One, the lease has to have been executed under a tribe's leasing scheme, and 2, that leasing scheme, before that a particular lease has been entered into, had to have been reviewed by BIA and approved by the Secretary of Interior. So, as you're thinking about this, and we'll get into this, I think, a little bit further in the discussion, when tribes think about taking that step to enact a leasing scheme, it raises a question about why they might want to do that. So one, there's the potential to significantly reduce the time that's needed to execute and approve leases, given that BIA is now out of the process. 2, that potentially opens up further opportunities for economic development and investment on tribal lands. It gives tribes an opportunity to really shape regulations in a way that works for them and the processes that they're used to, as long as their leasing scheme is consistent with 25 C.F.R. Part 162, and it gives tribes some flexibility, as to the kinds of activities that they want to have their own approval in leasing over, as opposed to submitting those things to the department. Let's go on to the next slide. So there's 3 basic steps in the review and approval process of tribal regulations that are submitted to the Department of the Interior for review and approval, so that tribes can start entering into and approving leases on their own under the HEARTH Act. 1, the tribal government drafts and approves a leasing scheme, and then it will submit that scheme to BIA for review. The second step is that there's then review by BIA, the Division of Real Estate Services, and the Office of Solicitor. And just kind of a practical tip. Let me just stop right here. I want to encourage folks that are on the phone, who are thinking about doing this, that have not submitted anything to the department before for approval concerning HEARTH regulations. Using BIA staff and Office of Solicitor staff to your advantage in kind of consulting with them and working with them, to ensure that what you're going to be proposing for approval by the department, the folks there are so knowledgeable, and it's just a great resource to be able to call on as you're kind of working through this process. So I certainly want to encourage folks to make use of both regional staff in the Office of the Solicitor and BIA, as well as staff that are located in Washington, to help you get to the best product you can in terms of what's going to work for your tribe, and submitting something to the department for approval. And so and there's often, I think, in that submission process, in once a tribe has approved a set of regulations that it wants BIA to look at and then approve, there could be some tweaking with what the tribe has submitted, and going back and forth with folks at Interior to make sure that the tribe scheme meets the statutory requirements. And so once that is done, then there's a final review by the Office of the Assistant Secretary of Indian Affairs in DC, and then of course, secretarial approval of the tribe's regulatory scheme. So the regulations that a tribe will submit for secretarial approval can be approved if a couple of conditions are met. Number one, the leasing regulations are consistent with BIA's current regulations at 25 C.F.R. Part 162. So it's always a good idea to take a really hard look as you're crafting any regulations that the tribe may want to use. 162 is as a model for what the tribe will propose, given that the HEARTH Act requires that a tribal scheme be consistent with the department's regs. And then two, the regulations must include an environmental process that has these three components. One, that process identifies and evaluates the significant effects of a proposed lease on the environment. There's an opportunity for public notice and comment period related to any significant impacts of the proposed lease. And then three, a requirement that the tribe respond to relevant and substantive public comments on the environmental impacts before the tribe approves a lease. And so let's go to the next one. And so just a couple of other nuggets from the statute about what kinds of leases may be authorized and approved by tribes under HEARTH regulations. Of course, business and agricultural leases, and per HEARTH, those leases can be for a term of 25 years, and then you can have an option for option for two additional terms of up to 25 years each. And then for residential, public purposes, religious purposes, educational and recreational purposes, leases that are approved under HEARTH regulations can have a term of 75 years. And then a couple of other restrictions. So the kinds of leases that can be approved by tribes are only those leases that apply to tribal trust lands. So that the tribe's approval authority won't extend to lands that are held in trust for individual Indian landowners. And of course, any leases related to mineral activity are also barred from approval under HEARTH-based regulations that tribes use. So that's kind of a quick rundown of statute and some background, and we'll move on to Cynthia.
Okay, I think we're actually going on to Matthew here.
My apologies,
I believe so. That's okay.
Okay, I guess this is where I pick up. This is regarding, this slide's just regarding kind of us pre-HEARTH. Something to touch base on was the BIA and the DOI were actually around a little bit before HEARTH was enacted. We're actually updating the C.F.R. that manages and controls the leasing regulations that the BIA adheres to. That's 162. So that got updated a little bit before HEARTH. So the Ho-Chunk Nation, just a little background on our land situation. We are a reservationless tribe. We're scattered throughout most central, southwest Wisconsin. We have land. We have no reservation boundary. We have lands in about 20 plus different counties, 3 different states, so we're pretty spread out. We have allotment, trust, and fee lands. So we were working on updating our processes and updating our forms and our leases to make them compliant with the new 162. And under that update, there was some good and some bad. The good with that update was that there was timelines put on the BIA to approve certain documents. Some of the bad that came with it is that they only approved it when they felt like they had a completed application, which included NEPA and other types of appraisals and insurances and whatnot. So, could we go on to the next slide, please? So our approval process is internally we had talked about our kind of land use that we had for trust, our trust properties. and we felt that it would be best to go after the three components of agriculture, business, and residential leasing policies. So we went ahead and the legislative approved three policies for to send out for 45-day public comment, which our public had 45 days to comment on, and we received a few comments from individuals. We took that into account and we submitted the initial policies on December of 2013. You can go to the next one. And those were submitted to the Interior, and we spoke to the Interior throughout the course of 2014. You know, there was a self-imposed deadline that was originally in place for the HEARTH regs, that they would have, I believe it was either 90 days or 120 days to approve submitted regulations, leasing regulations. Unfortunately, we didn't get any comments from the Interior back within that 120 days, within that time frame. They did ask for an extension near the end, which kind of helped some of the dialogue move forward. And the amended ordinances were eventually had to be reapproved by our legislature, which they reinstated at least 3 new leasing ordinances in language that we went back and forth with the solicitor's office on. Go to the next slide, please. And on early 2015, our 3 leasing ordinances were approved. So within that first month, we had 3 residential leases approved under our residential leasing policy ordinance. So it was a very quick turnaround. We saw it immediately. And can you go to the next slide? And with the approvals now, for one residential lease or a business lease lease, depending on how negotiations take place, we're looking at, on the administrative side, getting a lease approved within essentially a month and a half. And that includes approving it on our level. We have a few committees that we have to review it, that have to review all lease documents prior to legislative approval. And then once they're approved on a legislative level via resolution, usually our vice president has to sign off on it. And most of the process is just our internal process. Once we do our environmental reviews, everything is submitted to the BIA for recording. The approval, once it's signed off by our parties and the lessee and lessor, they're essentially approved on a tribal level. So we have, once they're approved there, we can go ahead and move forward. Of course, with funding, with Section 184, they do look for TSRs, so we do follow up with our LTRO and making sure those leases are recorded, and that's something we do stress is, even though you're approving these on a tribal level, make sure you take that extra step in getting it recorded at LTRO to make sure they show up on those TSRs, so when banks and other financial institutions are looking for proof that they were done properly, you can show them proof on your TSR, which usually are obtained by your local agency, BIA agency. So next step, please. And TAMS, I'd just like to express our Great Lakes agency has been great in allowing us to utilize the BIA's TAMS system. We have 3 certified users that are on site here. Our Great Lakes agency is about a good 3 or 4 hour drive from where we're at, so it's not really feasible to have individuals go up there just to encode lease documents. So we do everything on site. We're connected through a VPN. Everything is encoded and approved within TAMS by Ho-Chunk Nation employees. We did have to do a background check and everything that we needed to get, everything anyone needs to do to get TAMS access. But I can't stress enough for those tribes looking into HEARTH, that may possibly looking into getting TAMS access and reaching out to your regional office or agency in regards to getting some employees access, because there's a wealth of information on TAMs that you know, tribes should have access to. It's their information. So next slide, please. And since HEARTH, we've had about 26 residential leases, 9 business leases, and 4 ag leases. The residential leases are sometimes through Section 184 program. We do have our own in-house home ownership program too that we do. But like I said, we're not a very big tribe land-based wise. We're one of the smaller tribes. You know, the feed of trust process is our best friend because we're always looking to reclaim and regain our land base. But every single lease that goes through is another opportunity for us. And these are all leases that were done internally, and you know, without BIA approval or oversight. The only thing we had to do was record them. So I think we have some pictures here in the next few slides. Oh, well, this is why HEARTH. You know, I've got a lot of questions. Just when we went ahead and approved, I know a lot of other tribes were just looking towards business opportunities, but we wanted to kind of reach out and help our community. That's why we went ahead with the residential leasing. I can't stress the time for us, how much that helps not having to deal with the BIA's NEPA process. We created our own environmental internal process that I think is effective, and we no longer need to ask permission to the BIA to utilize our own lands. And I got a quote from our president at the time, who said that sovereignty, that's what we work for. We have drastically increased our ability to exercise our sovereignty over our own lands. Something I'll stress too is just, you know, having the right staff in place. I mean, yeah, it sounds great taking on all these responsibilities, but without having, you know, an individual in place with knowledge and what you're doing. I know a lot of tribes are still out there trying to get a lands office or a realty office or a real estate office. Make sure you have those people in place and those job descriptions in place and that knowledge and process in place to carry out these, or else, you know, you might as well be sending things to the BIA because it might take that long. So next slide, please. And a couple other points I wanted to point on. I know we decided to do residential, ag, and business, but we decided to take on the entire process, but you don't necessarily have to take on the entire process. You know, if you just want to take on the approval process, or if you just want to take on the environmental process, I believe, you know, that's something that the Interior's open to, and that was a couple options that we looked at. Initially was just taking on certain steps, but we went ahead and took on all of those. And kind of what we said at the beginning, this act really restores the authority of tribes to develop our own lands. You know, that was taken away through these long-term leasing acts and these congressional acts with these laws. That it was that authority to utilize our own lands, our own ways was taken away from us. And you know, the U.S. might say it was for our benefit at the time, but you know, I think we're at a point in time which the tribes can take on and those certain responsibilities without so much federal oversight. And it also reduces a lot of BIA processes for our leasing on a administrative level. You know, they can more focus on the cumbersome process that is allotment leasing. We deal with a lot of allottees out there. Fractionation's a huge problem, and you know, you do want to develop those lands if you can. So those tribes taking on HEARTH actually ease the administrative burden on those employees with the Bureau that have to work on both tribal leasing and allottee leasing. You know, so you take off some workload for them. Next slide, please. And this is just a few examples of some leases. We had a tribally owned jiu-jitsu gym, cross-training gym that he was one of our business leasing. He's in the Toma, Wisconsin area. And we also got a 6-year ag lease with Organic Valley, and that was one of our agricultural leases. And then we also did a veteran supporting housing complex, which is in Sampillo here in Jackson County, Wisconsin. And if you want to go ahead and click to the next slides, we got some pictures of some sites. This is part of the Jiu-Jitsu gym. This is on Ho-Chunk Nation Trust property. You can see the Ho-Chunk Nation flag up there with the Brazilian and American flag. You can flip through it a little bit. These are tribal members, tribal youth, and non-tribal youth that are welcome on here. So you want to go ahead and keep flipping through. This is just an overview of one of our properties. This is one of our larger properties, trust properties, the Kickapoo Valley Reserve. It's in Vernon County. We own about 1,200 acres there, and we lease a portion of it to our Organic Valley. If you want to keep flipping through. On site, it's not too pretty to look at because they are organic farms, so that it's not a pretty site. But if you want to keep flipping through, here's some more pictures overview of it. This was about a month ago, so it was kind of late in the season. I just wanted to get some pictures for the slides here for people to look at. And this was the ribbon cutting ceremony for our veteran supportive housing units that we did. Down there is actually what it turned out to be. If you could flip through, here's the ribbon cutting right here. We had some legislative reps, our president, some individuals with the local VA and veterans in attendance, and the first day we had 100% full occupancy. So that kind of goes to explain the need for homelessness, especially with veterans out there. And I think since day one, that has been 100% occupancy rate in there. So just some success stories I think we wanted to share. These are just a few of the leases that were approved under our HEARTH regs, and with funding timelines and end of the year cycles, we always strive to get these lease documents pushed through as fast as we can, and HEARTH has helped us that way just because once a decision is made by our legislature to move forward with the project, we can go ahead and find our vendors, get a lease in place fairly quickly, and get the project done rather than waiting 8 to 9 months for the BIA to approve a lease document. So I think that's it for Ho-Chunk. I think we're passing it on to Cynthia.
Yeah, okay. Thank you very much, Matthew. And you guys, it sounds really great things out there at Ho-Chunk. Okay, I'm going to talk a little bit about the Agua Caliente Band of Cahuilla Indians. As was mentioned in the beginning, I did work with the Bureau for several years. Most recently, I was a HEARTH Act coordinator and liaison. I went to work for Agua Caliente about a year ago. I'm their Trust Services Division Manager. And so I have the opportunity now to see the other side of the HEARTH Act, seeing how we're carrying it forward or how we're looking at it as an actual tribal government versus as the government taking a look at what the tribe's presenting. So this is, I really feel, the best of the two worlds. Our reservation at Agua Caliente is comprised of about 31,500 acres. It does span over 3 California cities, Palm Springs, Rancho Mirage, Cathedral City, and also various unincorporated areas of Riverside County. The reservation was established by executive order, and they actually had a couple of executive orders adding to it and some subsequent legislation. And the reservation's comprised of tribal trust lands, tribal member trust allotments. We also have some fee land. And because the federal government decided to deed every other section of land here to the railroad, we have that ever popular checkerboard pattern of trust and fee lands within the reservation boundaries. But despite this checkerboard nature of the reservation lands, on a combined basis, the tribe and its members currently represent the largest single landowner in the desert resort area of Palm Springs. And if any of you have been to our area, probably about this time of year, I would think. This is our good season where it's not about 120 degrees. You'll know that this is a resort area. We get an awful lot of tourism. Actually, it used to be primarily this time of year, and now it's become a year-round resort. And as you know, or the majority of the land is owned by Agua Caliente tribe or tribal members. And the tribe has used the BIA's leasing provisions under Part 162 to engage in many economic opportunities within this reservation. There are a combined total of approximately 20,600 active business leases, subleases, and timeshares, and these cover tribal and individual trust lands. The majority of the leases here are comprised of residential leases that have been enacted under master commercial leases. Okay, we can go on to the next page. There are just a couple photos here of what the tribe has done on the tribal lands. They've done some economic development through leasing, just a couple samples here. There's a 52 home project, Valera at Village Traditions, here in Palm Springs, been very popular. And we can go to the next slide. Could we move on to the, 18 single-family homes here. This is an artist rendition of 18 at Twin Palms. And then we have a commercial office building, and this is not the limits of what we have. We have quite a few other properties. These are just some of the highlights. And on the next page is Heritage Plaza, which is a commercial office building, and we've also undertaken some enhancements on this property, dealing with improvements to like the parking structure, utilizing solar. So we go back with some of these properties, and we're always trying to see what we can do to encourage rental, leasing of these facilities. They've all been very successful. At Agua Caliente, so we can go ahead and move on to the next slide. Thank you. In 2014, Agua Caliente submitted its business leasing ordinance, and it was approved and on September 23rd, 2014. So since 2014, Agua Caliente has been afforded the flexibility to utilize either the ordinance or the C.F.R. And this is one of the things about the HEARTH Act, is when you have your own tribal leasing laws approved by the Secretary of Interior, that does not negate your ability to go back and promulgate leases under the C.F.R. Now, you have to pick and choose dependent on each leasing situation. But sometimes a tribe may find that leases are better served by the existing C.F.R. And Agua Caliente thus far has come to that conclusion. So if we will go on to the next slide, factors that the tribe considered as we utilize the C.F.R. even after passage of our HEARTH Act was that we'd had prior successes on our business leases and our residential subleases utilizing the C.F.R. leasing regulations. Also, these projects, the larger business projects, were often better suited to a 99-year lease term. Usually that's a 65-year term and a 34-year option. Under the HEARTH Act, there is a maximum 75-year term if you're utilizing your options there. The 99-year term is not available to all tribes, and it was to Agua Caliente. So this is one of the incentives to go HEARTH Act for many tribes. You can extend your leasing term. If it is less than the 75 years, you can take advantage of that 75-year term under the HEARTH Act. Agua Caliente, again, we have that 99-year lease term under the 415. So also the comfort level of local developers. They've become familiar with the leasing processes under the C.F.R. things move very smoothly through the local agency in terms of the required documentation. They know that they can call on staff at Agua Caliente as well as the agency office to facilitate and get these processed. Also, we've been very fortunate in that the Pacific Regional Office and Palm Springs Agency, in our case, has been able to complete the reviews and provide the secretarial approvals fairly quickly. We also have an advantage that Agua Caliente has contracted the LTRO function. So in addition to managing the subleases, the commercial subleases, and rights of ways, we also have the LTRO here, and we have employees that are set up on both tribal and BIA systems. So we have access to TAMS, which is very important, as Matthew was stating. We also are able to establish tribally, as it is under a 638 contract, work with the BIA to establish those parameters that we feel will lead to better facilitation and processing and recording. So all of these factors work to benefit the tribe. And going on to the next slide, just talks a little bit more about how, for Agua Caliente, we have utilized our option under the C.F.R. It doesn't mean that we will not elect to use our HEARTH Act depending on the project, but we are, it's good that we have the sovereign right to go ahead and pick and choose now. It's not being mandated either one to us. And we have it there. We may utilize it in the future. But tribes may want to, even if they're not going to implement their regulations immediately, a new leasing law immediately, they may want to get their laws in place so that they have them and can build upon those as they move forward. And so I think yes.
This is Jody. Let me jump in on that, because you're on slide 35 there, right?
I am.
Yeah. So, as I was reading the points that were outlined on that slide, it just struck me that there seems to be limited to no downside to a tribe submitting a scheme for interior approval under HEARTH. And I don't know whether you or Matt could speak to that further, whether, given that, as you talked about Agua Caliente, finding opportunities to continue using the lease approval process under Part 162, and then sometimes using your HEARTH approved regulations for lease approval, there being benefits to both. I don't know that there is a downside, but maybe you or Matthew could speak to whether you agree with that view, or whether there are some drawbacks that folks who are thinking about doing this ought to consider before submitting a scheme for approval by the department.
Matthew, you want to go ahead and speak to that?
Yeah, I can hop in. Tribes, we've been leasing our property under these acts and codes for years. And I personally, I had a great relationship with the Great Lakes Agency, and we established a process under 162. And I think the internal debate for us initially was, do we want to go ahead and move towards a more self-governing internal process where we take on the responsibility? We still work with our Great Lakes Agency counterparts for our allotment leases, because we can't take that on under these HEARTH. But I think that's a question all the tribes need to ask is, you have a process in place. It's going fine. You've been doing it for years. Do you think this will benefit you? Do you want to break that process and try to take on this your own? That's the question I think a lot of tribes have, and the question that we had initially is, can we take this on? You know, do we have the capabilities? Do we have the staff? And depending on the number of leases that your tribe is processing, you know, that question might be a no. That answer might be a no to that question. You know, but for us, I think it was the right step. Like I said, we don't have that large of a land bases. Our leases don't come in as crazy as other tribes do. You know, but that's an internal question. I think all representatives and governments have to kind of question themselves before seriously considering submitting some regulations, or at least drafting some regulations.
And I would add to that you don't have to take on every leasing type at once either. That what's nice about the HEARTH Act is if you're thinking you may just want to start with, you know, ag or residential, you know, some tribes wanted to start right off with residential to provide housing for their members, housing opportunities. You can do that and then go back later and submit the other chapters or other areas and have those, you know, reviewed and approved as you move along on the process and you're feeling more confident and you've built up your staff and your resources.
Right, and so if you look at the Department of the Interior's HEARTH resources on its website, you'll see, I guess, roughly 26 tribes or so. I think that number is accurate. I don't know how when it was last updated, but it looked like there were regs that were approved up through 2016 as listed there. But you'll see tribes who have just had business leases or their business leasing regulations approved, and maybe one or two that also have agricultural or residential leasing regulations approved as well. But for the most part, the approvals have only been for one subject matter or the other, not all.
Mm-hmm. Yeah, there are a few tribes that I know from my time at the BIA that did go ahead and enter into all of them. And I know that there were a fair amount of tribes that actually didn't even have their infrastructure built yet, and they were going to basically shelve them. That seemed to work for them. They wanted to have them, and then they wanted to build their process around what they envisioned and incorporated into their regulations that were approved. So that is another way to look at it. And I think they've been able to get a couple more approved. And again, I'm right with you. I don't know that I have the exact number, but I think looking at the Federal Register, they might be up to around 32 regulations, and it's about 28 different tribes. And also Navajo has their own separate general leasing regulations, which are akin to the HEARTH Act, but separate and apart from.
Yeah, I know that a couple were approved under this administration. So if there's some fear for some tribes regarding that, I can tell you that this is they have an initiative for economic development and self-determination. So I don't think there's any fear on that side of things on getting these approved because there was two recently. I want to say within the last couple months, 2 tribes got their HEARTH regs.
Mhm. Yeah. Okay, and then.
I think we were at 36, and this slide, just kind of walks through some of the potential benefits of tribal leasing after the enactment of the HEARTH Act, and we kind of mentioned a couple of these before, and Cynthia and or Matt, you might want to weigh in specifically here on experiences you've had, but one. Economic development and how the streamlined process, obviously reduces the time it takes to get leases approved, but also opens up more opportunities for economic development on tribal lands in tribal communities. Two, kind of tribes being able to focus in on those areas that are most important to them, and we talked a little bit about that, leasing schemes that might only go to one purpose or another, and not, having to, implement some broad, comprehensive leasing scheme, across all subject matters. And then, 3, having the flexibility that we're talking about. It just strikes me that there's just little downside that, if you have a HEARTH approved or department approved set of tribal regulations under HEARTH, you have the option of using that scheme to have leases approved, or using the 162 process that still sits there and is available to tribes if they want to use that. So Cynthia, Matthew, any other thoughts to add on this slide?
One that I would add is that if a tribe does submit regulations, even though they have been submitted and approved, there is a mechanism to amend them, to modify them. Non-material changes, and you need to check back with the BIA on this, but non-material changes may not have to go through such a rigorous process or reapproval. Material changes, I believe they still look at reapproval of that portion, but caveat, do touch base with your region and your local agency, and they've got a great crew, up in DC that are working on these that will get those answers back to you. But they're not cast in concrete once you submit them. The tribe, it's your law, it's your regulations, and if you need to modify them to serve your needs as they change, you can do so.
Do we want to go on to the next slide? So, Matthew and Cynthia, I don't know if you want to talk through some of the challenges that are just, identified here at a very high level, but, some of the subjects here, talk about how they could potentially make implementing a tribal approval scheme more difficult, or, make tribes think, really hard about whether they want to take this step to have their own, leasing approval process. Can you speak to any of the points that are on the slide here?
Yeah, I'll kind of hop into that. Kind of what I said before, having the right staff in place, looking towards getting TAMS access, because I think that goes a long way in regards to getting access to your tribe's information that the feds have on you. The legal descriptions for all your tracks, the track numbers and your track history, even the allotee information, it's all great information. But for some of the things you got to keep in mind too is once you pass this, if you were to try to amend it, like Cynthia had said, those amendments still need to be approved by the Interior after the fact. So you can't just amend it in-house with changes without, I believe, first contacting the Interior and getting it approved by them, correct? Cynthia?
At the time that I was with Interior, there was a difference between non-material and material changes. So non-material, maybe wordsmithing a little bit, whatever. At that time, did not need to be resubmitted. But if you're changing things that are material and substantial, yes, they would need to go through for approval. But that's where I say connect with your region, connect with your agency to get the current and proper guidance on that.
Yeah. So if your tribes are kind of going through like restructuring or constitutional reform, that's something to keep in mind too. Is if you got another entity approving or another authority approving the documents now, you now have outdated laws that you need to get amended and reapproved by the Interior. Or if you're looking to substantially change the process, and that goes to when you are executing these leases in-house, try to adhere to your code that you passed. You pass that code, you put those stipulations in there and those restrictions on there. We chose to do a certain approval, mandatory approval within a certain amount of time if we didn't respond to a lessee. So we put those on ourselves to kind of push ourselves to get these approved. So once you approve your code, make sure you're following what your ordinance says, what your laws say, and even if you do not if you haven't contracted LTRO, when you record those leases, LTRO is still doing their assessment on it. They're doing making sure all the legal descriptions are correct and everything. So occasionally they'll catch some things. Most of the time it's just legal descriptions, discrepancies on LTRO side, just making sure we're adhering to and putting the correct description and citations within our lease documents. So that's always something to keep in mind.
And looking at in-house resources here and processing time, I think a lot of times tribes will enact HEARTH Act. One of the reasons that can be a driving force is that sometimes at some of the agencies or regions we do have some delays, but that can also happen on the tribal level. So although you may not be a tribe that wants to shelve it, you may want to start right in. If you do start right in, if you don't have adequate staffing or your daily procedures in place, you have your overarching ordinance, your overarching law, but you still will need to give staff guidance and training and have your in-house expertise, or your processing time may be a bit more of a challenge than it was when you were sending it out, to the BIA. So that might be something you want to consider before you actually flip the switch.
And that goes kind of back to the contracting, 638 contracting and compacting, those realty functions from the Bureau. If funding's an issue, that's a funding source that you can kind of apply for. We got a 638 contract for realty functions. Unfortunately, due to our connection with TAMS, we can't contract LTRO functions because we don't have the capabilities to scan. So we've chosen not to contract LTRO functions. But that's another source of funds there if you're looking to really dive deep and take on some realty challenges that your tribes are facing.
And, if I might add to that, Matthew, there are a lot of tribes that, for whatever reason, can't contract the LTRO function. As I mentioned earlier, Agua Caliente, we have done that. And under the directorship of Connie Medina, they've opened up that LTRO function, and they are contracting with other tribes to execute those functions. So you may want to, if you shoot me an email, any tribes that might be interested in that, I'll be sure to forward it to Connie at Agua Caliente. That's something that it's just getting out there in Indian country, but I think it's proving successful. So you may want to keep that in mind. Don't let that LTRO function hold you back.
Any other points on this slide that you guys want to make or add to?
I think we're going to talk a little bit further about the lease enforcement. We could jump on it now, or I think it's the next page. So there we go. I was just going to add in that one of the things is that once the HEARTH Act is enacted, or once tribal leasing law is enacted under the HEARTH Act, and the tribe actually starts to implement it, it is the expectation, I believe, of the Bureau that then the tribe will manage the aspects of those leases that are approved under regulations. So there you may have some logistics to deal with, perhaps finances, to look at your enforcement. You want to have that beefed up. How are you going to handle that? So also situations can still arise outside of the approved regulations. For example, if you have a trespass on an unapproved right-of-way, the BIA probably will still have the jurisdiction to act and can still act on your behalf. But it is only upon reasonable notice from the tribe that the secretary, and this is right out of the HEARTH Act, may enforce provisions of or cancel a lease. Again, the expectation is that the tribe is going to handle these things. Doesn't mean that the gate's closed, and again, relationships between tribe, agencies, and regions are very unique within each agency, tribe, and region. So there may be more support from one area of the nation than another area. It's just something to be prepared for and have worked out ahead of time. I would encourage that.
Yeah, you know, that's a really good point, Cynthia. I'm glad you brought that up. You know, because on one hand, I think you could look at what's here and you could take the view that, well, interior is really hands off now. But the HEARTH Act provides places in which the secretary can exercise discretion to get involved if there's a problem with the lease, or if I guess there's another provision that talks about if an interested party, after exhausting whatever remedies the tribe has made available, that interested party can go to the secretary and say, hey, the tribe is not complying with its own regulations, and that secretary might look at whether a tribe is acting consistent with the regulatory scheme that the tribe has enacted and the department has approved. At the same time, there's a provision in the act that says the United States is not going to be liable for losses sustained by any party to a lease that's executed under tribal regulations that are approved under HEARTH. So there's kind of both sides of that coin, so to speak, in this amendment to the Long-Term Leasing Act.
Mm-hmm. And of course, you still need to, as a tribe, provide the BIA with a copy of all your lease documents. It's going to be encoded and put into TAMs. There needs to be a mechanism where the BIA can keep track of trust assets. So that is one manner that they do so. I saw that actually implemented into many of the leasing regulations. Matthew, I'm not sure if it's in Ho-Chunks or not. Some tribes don't have that provision. The earlier tribes that had, or tribes that had the earlier approvals, but I believe that that provision was implemented because it was something required by the Act. And are you doing that, Matthew? I know you're encoding all of them on your own anyway, right?
Yeah, and they kind of get the copies that we send to record are sent through the realty section of our agency first before they reach LTRO. So that's us providing it to them. But I will note and say that it says copies, not originals. So don't think you have to send your originals there, although LTRO does prefer to record originals. The HEARTH Act itself and what's in our leasing ordinances are just copies. So you don't need to, send your only originals to them.
All right. Well, for tribes out there interested in drafting their own HEARTH Act regulations, there are some suggested materials to take a quick look at. First of all, obviously the HEARTH Act, which is at 25 U.S.C. Section 415H, is the actual legislation that authorizes the approval of tribal regulations by the department. BIA's leasing regulations are also really important to look at, obviously, because it's important to demonstrate compliance with the general purposes of the federal regulations when leasing under HEARTH Act regulations. The Central Office's National Policy Memorandum also has really good information, and the BIA has a checklist that is used when reviewing the regulations on the federal level. And so Those materials are all available at www.indianaffairs.gov/BIA/OTS/HEARTH. And so we're going to move on to the question and answers phase.
Yeah.
Unless you had something to add?
No.
And so we have a fair number of questions here. And so the first question is, if a tribe has its own leasing ordinance, will BIA approval of leasehold mortgages still be required?
That's the $64 million question. I know that in some of the tribal ordinances, they have provided in there that they can approve their own mortgages. The tribes are the ones who will sign on it. And I do not believe, and again, I always encourage go back to the Bureau and see what the current policy is. But at one time, the ones that have gone through, it has been that tribes had the authority to approve their own mortgages, but we did encourage, keep in mind, if you're going to approve them, that you would still want to consider incorporating practices so that your lenders, when you want to go and obtain a mortgage, they're comfortable doing so. They have faith in your process. They know that you're going to get that loan recorded and on the TSR, because that is something that your lenders are going to want to see. They're going to want to see title from LTRO. They're going to want to see the lien reflected on the mortgage, and that's a piece that sometimes is missed, and then that can cause great delays further down the road. So I would really talk with, again, the practices with the Bureau and the regions, what they're doing. Talk to your lenders, talk to your lending institutions, and see what's their comfort level. Look at HUD, see what the comfort level is. That's my recommendation on that.
I can tell you for
Matthew, yeah.
We did, I don't know if we snuck it in there, but yeah, Chapter 5 of us is of our residential leasing code is approval of leasehold mortgages and recording, and it said after the Secretary approves this code, all leasehold mortgages which are authorized under this section shall be in effect without federal approval under 25 U.S.C. 415 unless the Secretary rescinds the approval of this code. So, but there was a stipulation in there that, of course, we did want to provide all the copies to LTRO to record. I don't think we can stress that enough on how important it is to get the encumbrances, the leases, anything you have on those TSRs. So when you're outside looking for funding, you have those in place as proof. And if we're talking about other types of codes and whatnot, it's good to have your eviction code on there, zoning and land use, all those types of and everything in place to solidify the laws that you have to help justify these individuals giving loans to people on your lands. That's what the banks want to see. They want to see an eviction code in place. They want to see a court with competent jurisdiction over the eviction proceedings. Yeah, that's what I got to add to that.
We have another question. So the question is, since tribes still have the ability to use this 162 process along with their HEARTH Act regulations, if you do decide to go with the HEARTH Act model, you can change your mind about that at a future date, right?
You mean and go back to using 162?
Yes.
Yeah, I think if this is what the question is being asked, right? A tribe, if it has both schemes available to it for leasing, the tribe just needs to make the decision itself whether that particular lease it makes more sense to move forward with approval under its own regulatory scheme, or if it's one that for whatever reason, circumstances, maybe it's the lessee that you're dealing with, wants to have Interior involved in the approval process. then maybe it makes sense for you to go the 162 route instead. But you have that option available to you. I think as both Matthew and Cynthia have talked about, the tribes that they're working for, have used those options rather effectively.
Got another question. So since it's a pretty significant number of tribes that have submitted and gotten approved their HEARTH Act regulations, does anybody have a sense as to how many tribes are actually processing leases under their HEARTH Act regulations?
I mean, I would guess all of them. You don't know that for sure. I guess you wouldn't know that for sure unless somebody from BIA told you about whatever materials they're receiving from tribes based on submissions after tribes have entered into leases that the tribes have approved themselves. But given the efficiencies that are provided and other benefits that are offered, one would think that most, if not all, of those tribes who have had one or more types of leases, leasing schemes approved, that all of those tribes are doing that now.
Well, and as I mentioned, Agua Caliente, we've not utilized it in our recent choices as far as leasing goes. We still have it. It is there. But some tribes also, keep in mind, had them approved and they were building their infrastructure. And so we have a little bit of a delay, I think, from the time that they started with those initial approvals before any of them actually started filtering into BIA. And then I also think that there was a little bit of perhaps misunderstanding as to whether or not BIA was to accept, record, encode, all of that. This all hit in 2014, and all of a sudden, the process had to be developed. So the law hit before the whole process was developed. And so there's a little bit of catch-up time there. So there may be more tribes that are actually implementing it. If you go back to, say, a year ago, there may have been more actually doing so than the BIA could account for at the time. I would think that now everything's on par.
So there's a good question here. Are there template regs that are available for a tribe to use as a starting point? And I think the answer to that question is yes, that if you go onto the website that Jake referenced earlier, where there's other materials that Interior provides, just other guidance about the HEARTH Act, I believe there is a template there. And Cynthia or Matthew, you may have more to add on that. I think that's right, but please correct me if I'm wrong about that.
There are templates there. One of the things we did was to always advise tribes, use them solely as reference. It's not advised that you cookie cut or anything. There's different references out there. I don't know what may have been changed in the past year, but it's not really a one-size-fits-all, because all of our tribal nations are very unique and different in their own settings, and they're more discussion points, and for people for tribes to put out on the table and say, hey, this is a good idea as to the way we want to go. Granted, if there's one that's a perfect fit, then it's there to utilize.
Yeah, I think the checklist and the memo, for us it was the memo that we kind of referenced. We were part of the group that was kind of before that checklist came out, but looking at the checklist and the memo, just looking at those two documents and trying to reference, and the actual act itself I'd go back and looking at all those documents and trying to hit all those check marks and trying to make sure you're putting in your code what you actually want to do, I think would go a long way. But going back to what Cynthia said, we're all unique. We all have unique circumstances, so drafting them from scratch might seem a little scary, especially when you're dealing with like federal approval. solicitor's office looking at them, but to us they were more than welcoming and you know, just telling us the feedback that we got back and forth with them. You know, I think initially we sent them a monster. Initially it had a lot of different ideas and a lot of different processes in it, but eventually we got it down to what we wanted it to get down to, and you know, they're there to help you. I think the Interior is very supportive of tribes submitting these.
So we've received a few questions about just kind of confirming which land statuses are eligible for HEARTH Act regulations. Specifically, there's been questions regarding tribally owned fee land and then also allotments. So maybe Jody, could you address that?
Yeah. So if you look at the Long-Term Leasing Act, if you look at Section A, it says any restricted lands, whether tribally or individually owned. So we're talking about trust or restricted fee lands, but then the HEARTH Act itself goes on to say expressly that that it does not apply to individually owned Indian allotments. So it would just be tribal trust or tribal restricted fee lands. And then, you know, with respect to tribal fee lands, you know, that's not covered per my read of the statute. And I think BIA, at least in one region, has put out some guidance saying that it will not approve regulations that expressly extend to tribally owned fee land. So, Cynthia or Matthew, I don't know if you have other you know, direct experience with any of those issues with BIA, but that's my read of the statute and the guidance that's out there.
Well, I know there's some pending legislation regarding tribally fee land because there's been some confusion out there in regards to the Indian Non-Intercourse Act in regards to if tribes can actually lease or sell or transfer their own fee lands. So I know there was a subcommittee hearing, House hearing regarding this, where some tribes from Oregon were trying to get legislation passed so they're allowed to actually lease and sell their fee lands, because some title companies were coming to them and saying, according to this the Indian Non-Intercourse Act, which is an act from like the 1700s, late 1700s, it could be interpreted as that the federal that we can transfer or lease our own fee lands without the federal government's approval. So I think there's some questions there that still need to be answered. I know throughout the years, some other tribes actually went to Congress and got approval to lease their own fee land. The Miami Tribe of Oklahoma, Fond du Lac did it. So that's something to consider. But I would say for sure HEARTH is not covered under fee. Our agency wants nothing to do with our fee lands.
Yeah, and in the time I was at the Bureau, it was across the board. Fee land was not included under the HEARTH Act.
Right, yeah. And you know, the only other thing I would say to folks is that, you know, as you're thinking about, you know, specific legal questions concerning whatever circumstance your tribe is in, it's always important to just, you know, go back and consult with the tribe's legal counsel about, you know, specific questions, and, you know, there could be, you know, statutes that are specific to your tribe that, you know, will impact how, you know, other statutes apply. So it's always good to, you know, have that legal advice from your tribe's attorney to, you know, to make sure you're getting certainty with respect to the process.
Cynthia and Matthew, we got a really great question, sort of about cost. Somebody is interested in knowing sort of what that looks like on the travel side for implementing these regulations. Do you guys, either of you, have a sense of sort of what it costs to do the regulations and then also to run all the leasing?
Matthew, you want to tackle that one?
Well, like I said, we're not a huge tribe. We do, I mean, it is a continuous, we do have a lot of applications in the works, but we only have one dedicated lease specialist. She works on all of our fee, trust, allotment, leases. She's just one individual. The 638 contract money does help out, but it doesn't cover her salary. But I mean, depending on the revenue that you're generating from these leases, that usually justifies any type of funding issues that we deal with our legislature every year. Is that, you know, we're one of the only operations that, you know, the lands is really the only one of the things that can help generate revenue on tribal land. So as far as cost, I can tell you the Ho-Chunk Nation, we have one lease specialist. We're given line items for our paper and whatnot. The processes are all internal subcommittees and presentation to our legislature. Occasionally there's travel and trainings, but other than that, the cost isn't too huge. But I do think that tribes looking to get into HEARTH do need to look into investing in land or realty type sections or divisions within their tribes if they haven't. Getting either a dedicated attorney or dedicated staff to carry out these processes that you're taking on from the BIA, and just getting the right people, knowledgeable people in the right places.
And I think part of that question too was about just the cost involved in submitting for the HEARTH Act and the actual submission of your ordinance, you know, your tribal laws that are going to cover it. You know, there isn't a cost, of course, as far as putting them to the submitting them for approval, but most tribes would want, or most tribes utilize legal counsel, and they work very closely with their legal counsel throughout the whole process. In fact, when we talk about specific ordinances that were submitted for approval, generally there would be a meeting between BIA representatives and tribal representatives that wanted to be a part of it. Sometimes tribes simply turned it over to legal counsel, and sometimes it was the tribal representatives and legal counsel. So that's where your expense on the tribal side, other than, you know, your infrastructure, as Matthew's talking about, you know, your personnel, where you're going to house your personnel, how many people do you need, what's your volume of leases. You know, Agua Caliente, we have on administering 20,000 subleases, we have 7 staff members that handle that, but these have been in place a long time. These were under the C.F.R. They're long-standing leases. They're well-known processes. There's a system already in place. It takes a lot more, I think, just to implement it.
All right. We have another question. This one's specifically to Matthew. Have you noticed, or have you had any issues with lenders? Specifically, are lenders comfortable with your leases? Have you had any pushback with respect to financing related to leases?
I would say yes. Initially, the HUD doesn't want their documents touched. If we're talking Section 184, the Section 184 program, popular home owner lending loan program in Indian country right now, HUD doesn't really like their documents to be touched. But when you enact your HEARTH code, you want to make sure your lease documents reflect the citation for the proper law that you're approving your code under. So it's no longer the Long-Term Leasing Act or C.F.R. 162. Now you're citing your own, for us it's our Ho-Chunk Nation code that you need to cite. So we did have some problems adjusting the lease document to reflect that. We did get approval by HUD to make those changes because they weren't, kind of going back to Cynthia said, they weren't so materialistic. You know, it wasn't so, it was just strictly extending that 25 plus 25 years to 75 years, and also changing everything in there from where it was saying the secretary, because the secretary no longer is carrying out duties under the HEARTH Act, it's the tribe, and replacing it with the proper language, and then also the citations usually on the beginning of the document. So yeah, just keep in mind when you're going about changing your lease documents, banks and other financial institutions, they're used to seeing certain things certain ways. So we initially didn't reach out to banks when we did our HEARTH Act, so we did get a couple questions in regards to, oh, this lease looks a little different. The page numbers did change a little bit. But other than that, since then we haven't had a problem. And really it's just making sure you're getting that lease recorded properly. Really they want to see that certified TSR. That's what they want to see. Because right now you can't really get a loan just by a lease. We'd like that, but they want to see a certified TSR. So that's why we're still working with the BIA, getting the lease process knocked down as much as we can, and getting that certified TSR in their hands so people can get homes built as quickly as they can.
Sort of on that same question, Cynthia and Matthew, have you had any interaction with USDA and VA for loans? Have you had kind of the same experiences with HUD, or have you run into anything with either of those two agencies?
Well, from Agua Caliente, we have not. But in terms of what I saw as I was with the Bureau and the interaction between those organizations, I know that USDA was very proactive in wanting to reach out and understand the HEARTH Act and work with tribes on this. So again, you know, with Agua Caliente, we've been very successful in that lenders are comfortable here and we don't have issues in getting approvals on the loans. But as again with HEARTH Act, I saw USDA and of course HUD, you know, was working as well with the Bureau and reaching out to the tribes. I know they're still doing so. Matthew, you may have had more that's actually applicable to the HEARTH Act leases.
For us, I mean, USDA's it's been great we do a lot of ag leasing, mostly on fee lands, and they're mostly just contracted out. Like we have Organic Valley, we do have local farmers in a lot of places. On the VA side of things, we're one of the few tribes that we don't have a MOU with the VA yet. We're still working on that. But we do have our own, and I think a reason for that is because a lot of tribal members go through our own internal home ownership program, which we have a separate home ownership program specifically for veterans. So a lot of veterans get their funding that way, and you know it's like a zero interest rate, and you know, so it's really good for tribal members just to wait in that queue. So we don't have very many tribal members applying to the federal, the U.S. VA for loans. They're mostly looking towards our internal home ownership program. But I am trying to get a MOU in place between us and the St. Paul Regional Office VA to get that in place in case any tribal member down the line would want to apply for that loan. So we haven't had to talk to the VA about our loan, our lease and HEARTH Act yet.
And I also want to add that there are individual lenders that are really reaching out, and they're going to a lot of our, in Indian country, a lot of the seminars and different functions that we have set up, and they're there. You know, they have their booths there and they're on site, and they've worked some of these kinks out, and they're working hand in hand with, you know, HUD or the other organizations. So keep that in mind. You know, reach out to these people. You know, I've got various names and things as well, but take a look for them when you go to our functions in Indian country, because they're out there. They know tribes are engaging in this, and they're there to help, you know, get us this funding, because that's so important with our home sites and things to get these mortgages through. So I just want to recommend you check into that.
Yeah, and going back to what I said earlier, I think that's a lot of fear that some tribes have is they have a system in place with funding sources, and they've had it in place for years. So I can understand where some tribes are a little fearful in going into the process, but from our experiences, you know, it hasn't impacted any of our projects. Like I said, we had 3 leases approved within the first month of enactment. That started from enactment, when our HEARTH codes were enacted, and you know, it's been clear sailing from there. Really, we really hadn't had a problem.
One other point I wanted to raise that, you know, often timing for approval can be a point of frustration for tribes, and there was a question here about a holdup, I think, that one tribe may be having in the review process. Maybe they've been waiting for more than a year to get their regulations approved by Interior. And, you know, I think as somebody pointed out earlier, under the statute, approvals of regulations that are submitted or some decision whether to approve is due within 120 days. But of course, the statute gives Interior the opportunity to extend that deadline after consulting with the tribe. Cynthia, I didn't, you know, kind of being on the inside, I don't know if you can speak more to, you know, timing that folks can realistically expect which to get an approval. You know, let's assume they've gone back and forth with the solicitor's office and or BIA about tweaking a submission that they've made, and it's kind of, you know, in place. You know, what's realistic in terms of the amount of time it might take to move an application through?
Well, that's, you know, fact specific as to what the regulations entail, but I can just offer you maybe some minor insights that might be of benefit. And first off, as far as 120 days that's in the HEARTH Act, I just want to emphasize that that is not a deemed approved situation. Under 25 C.F.R, when you're looking at the regular BIA regulations, there are situations that are deemed approved situations where certain acts aren't completed in a certain time frame, bam, they've got approval. There's your deemed approved. At least at the time I was with the Bureau, it was interpreted I wasn't the one interpreting it, but it was not deemed approved. It didn't specifically state that, and that is the way it moved forward. So I haven't heard otherwise to this point. Again, check with the Bureau. But one thing that helps, you know, your local agencies and regions will definitely have input into this process. And just if you don't already have a good conversation going with your agency and with your region, before you submit your HEARTH Act regulations for approval, I recommend that you engage in one, because what will happen is it will go to central office, and I can't speak to exactly the step-by-step process there any longer, but it does go back out to the regions and to the agencies, and comments are made, observations are made, and then it's going to come back and, you know, you're all going to talk about it. Now, it's your regulations, it's your laws, and the HEARTH Act imposes minimum requirements. There's also that consistency. You don't have to mirror, but you have to be consistent with the C.F.R. So if you meet with your agency and your regions and you find out what's working for us now, what process is working that as a sovereign nation, we're comfortable putting that into our regulations or agreeing with the agency to do so. You may not have thought to put it in. They may say it will help the process. It's your sovereign right maybe to decide that issue. If you can work those kinks out before you submit it, I think approval time may flow along a little bit smoother. Other than that, I will refer you back again to your regions, agencies, and central office as to time frames.
Yeah. And Cynthia, let me just piggyback on what you're saying there. You know, for folks who are having, you know, frustration, you know, waiting around for the department to approve, you know, a submission you've made, or you're thinking about the process and as you may submit something, you know, don't underestimate how helpful folks in BIA and the solicitor's office may be. And I would say, you know, it's good to have clear lines of communication with both of those offices, just not one or the other, because you know, both BIA and the solicitor's office play really important roles in getting travel regulations approved. And so, you know, you want to make sure that you know, you're able to have conversations with both, so that there are clear lines of communications, and there's a good understanding about, you know, if there's a problem, if there's a holdup, what the source of that is, and you know, doing your best to get to the bottom of that. You know, the department, you know, can sometimes be a bit of a black box, and you may not be exactly sure about, you know, what's going on where with respect to any approval that you're waiting on. But you know, doing, you know, your absolute best to make sure you're having those clear lines of communications is really important.
Mm-hmm.
Yeah, you know, and somebody just asked a question kind of related to this about, you know, the priority that's being given to HEARTH Act approvals by the Assistant Secretary's office right now, you know, once I guess region review is complete. You know, I don't have an answer to that. You know, certainly as far as the, you know, if you look at this administration and the political team that's now in place in Washington, you know, that team is filling out. It's not, you know, completely done yet, you know, but there obviously is a principal deputy assistant secretary for Indian Affairs and a deputy assistant, and there's also you know, a BIA director that's in place, and so you know, there's personnel there, but you know, I can't speak to, you know, what level of priority the department is currently giving, at least at the political level, you know, to moving these approvals on.
Mm-hmm.
Yeah, and I would add to that, it wouldn't hurt just to chirp. I mean, if you have a VP or tribal council sending letters, giving notices, or if you're invited to, you know, some kind of House committee, you know, just providing within your memo, usually that they provide a memo for those hearings. I know for us, we were invited to speak at one of the subcommittees for Indian and Alaskan Native Affairs, and it was regarding another topic, but we had our legislator that was invited go ahead and mention, you know, we're still waiting on that, our approval for our regs. It's been 120 days, you know. So even if it's you have lobbyists or people out there in DC talking to those, I know most of those are just for other purposes, but this is a federal function, an approval process. You can have them reach out on your behalf. So anything you can really do to chirp. I know for me, I was waiting over a year, talking back and forth to the solicitor's office. I had leases that I wanted to approve under HEARTH, you know, that I went ahead and just proved under 162 because it was taking so long. But no, I understand the frustration. I was always calling my attorney saying, hey, anything regarding HEARTH yet? And they'll be like, hey, you're going to be the first guy to know. So it could be a little frustrating at time, but I can tell you the end result is very much worth it. At least on our part it was.
I think we have time for just one more question, and the last one is going to be kind of for both Cynthia and Matthew. What does the actual approval process look like in both of your instances? I think we have individuals interested in knowing whether it's, you know, a tribal council decision or if it's some other means of the decision making within your two tribal governments.
Do you want to go ahead, Cynthia?
You know, I would need to pull mine up. Because we're not putting them through right.
I know mine like the back of my hand. So, okay. Well, initially we get an application. We look at land use and zoning to see if the application and what the individual wants to apply for is within the permitted use. If it is within the permitted use, we forward that application with draft leases and a draft resolution to our land development team. They're in a subcommittee within an advisory committee within our executive branch, and they give a recommendation to either approve or deny the application. Usually at that committee, if there's any archaeological review or cultural review or any type of review that needs to take place, appraisal or anything, that's where it takes place at. And once the lease is recommended for either approval or denial, we take that lease in front of full legislature. Our legislature is comprised of elected representatives from each district within that the Ho-Chunk Nation has, and there they give their either approval or denial for the lease application. That usually is the grunt of the work for us. That usually what takes the longest. We have to wait for a land development team meeting, wait for a legislative meeting, and then once we get the resolution authorized at full legislature, that allows us to submit to our vice president for signature. And once he signs it, it's deemed approved. The lease is approved. So they, that's all. Sometimes that's all is really needed to move forward with projects if the fund source is right. But for the Section 184s, after that, any leases on trust, after the leases are signed by the lessee and lessor, and if there's a upfront payment that we have to get, we get that, and we give all those documents to the Bureau of Indian Affairs, our Great Lakes agency here in Wisconsin, and our LTRO is located in the same building up in Ashland, Wisconsin, and they record it within their LTRO, and it's sent back to us, and within probably less than a few weeks after that, it shows up on the TSR. We also usually request a certified TSR when we send it up for recording. If it's somebody looking for a Section 184 loan, and that's how long it takes. Usually it's just to get approval. You're looking at a month and a half to get it recorded and approved. You're looking at 2 months, two and a half months. But the old way under 162, I'm sure everyone has dealt with with NEPA on their side and environmental reviews on those side. All those are done in-house, according to our code. So that's our entire process from beginning to end.
And I'm sorry to disappoint, but I'm on another computer system, and I did not bring a copy of our ordinance. We're not implementing it on a routine basis. As I explained, we're using the C.F.R. because it has been to the benefit of Agua Caliente since we've passed the HEARTH Act regulations. But we do have them. We do know that they're at our disposal, and when the particular facts support utilizing that ordinance, we will at that time.
I will note too that document management, that's another important thing I'd like to stress is these documents, whether they're mortgages or deeds or leases, whatever you're dealing with, once we get those originals back signed, you want to make sure those are appropriately stored. We do it in an acid-free, we clean them, take off all the acid. There's pads online you can buy. Store them in acid-free folders and acid-free boxes, and they're taken to our records building, which is not located on trust, but it's contiguous to trust. It's just in our backyard, and it's stored in a temperature-controlled room. So because some of these leases are getting up there in ages, we have leases from the 60s that, just from handling, people normally routine handling them, they're starting to fall apart. So making sure you're maintaining those documents and storing them appropriately, because now you're looking at a living document that's going to be 75 years active, not just your normal 25 plus 25. So I'll stress that too. You can add that to the cost, that I guess, because those kind of cost a pretty penny. But in the long run, you're saving yourself headaches from you know, missing mortgage documents and deeds because you had people's hands on them all day. So just keep that in mind too, I guess.
Thank you very much, both Cynthia and Matthew, for those responses. It's been really some great questions today, and these have been really exceptional presenters. We weren't able to get to all of the questions, but as you can see, there is contact information up on the screen right now. If you have specific questions or you didn't get your question answered, please reach out. I think everybody on the panel and here would be very interested in helping you get the answer to your questions. One of the questions that didn't get answered during the programming was whether or not the slides will be distributed. We will send out the slides following the presentation. And I just wanted to say thank you to everyone who joined us today for this webinar. I think it went really, really well. And I want to also thank the presenters for being a part of this. It's a really important issue, and I think it's a really great thing to know a little bit more about. So with that, I think we'll be signing off. So have a great rest of the day.
Thank you. Have a good holidays, people.
Thanks. Take care.
Thank you all. Thank you. Bye-bye.